I am the citizen of British India. What I said was heard by others. Today is July 26, 1917. The only witness examined today by the Champaran Agrarian Inquiry Committee was Mr. W.S. Irwin, the manager of Motihari Limited. Examined by the chairman, witness said his concern consisted of 6 factories. It was an indigo concern before, but it was not now. He converted the Tinkatia system in 1911 by taking their Tawan of Sarabeshi. Under the Tinkatia obligation, every ryot had to work 3 quotas of the indigo. The claim was against every ryot. Witness had taken Sarabeshi in Mukarari villages and Tawan in Tikhadari villages. Asked whether he claimed that an exclusive right was created because the Raj had allowed it, witness said that the Raj had taken a good deal more than they were allowed to collect under the terms of their leases. When he said government recognized the obligation, he meant that he recognized it tacitly, because they said that so long as indigo was grown, rents could not be raised. Witness then gave similar evidence to the previous witnesses about the imposition of fines and employment of labor. To Mr. Gandhi, witness said that he had not fined any person rupees 500 when he told that Mr. Gandhi had a man who alleged witness had fined him 1,000 rupees. Witness said, "If Mr. Gandhi were to remain in this part of the country for the length of the time I have, and it is 35 years, he would have convinced what a consummate liar the Champaran riot is." There were several good qualities in the Champaran riot, but certainly truth was not one of them. Before his letter to the pioneer, there was not a single complaint made against him. Mr. Gandhi said that from Mr. Haycock's summary, it appeared during the last 4 years, 27 petitions have been sent to the collector from 20 different villages against the factory. Witness said he had 30,000 tenants, and if in 4 years 27 petitions were sent, it was natural that they might not come in his notice. Witness was next questioned about specific cases of oppression, and in one it was alleged he had destroyed the crop of one, Lakhan Rai. Witness said that in November 1914, at a court auction sale, he had purchased a certain plot, one of Alam. A portion of the holding was in Lakhan Rai's name as a sub-royat. But at the attestation, Lakhan Rai told the settlement officer he was no longer a sub-royat. Witness here produced a certified copy to substantiate his statement and said that at the time there was a crop of oats on the land and he let Lakhan Rai have half of it. In May, he ordered the whole of this land to be prepared for indigo, and it was then discovered that in 2 quotas in a corner Lakhan Rai had surreptitiously sown China. This he had absolutely no right to do, and witness men plowed up the whole land. The crop was of very poor quality and the damage was very slight. With regard to a second incident about which he was asked, witness admitted that to a certain extent he was in the wrong. The story relating to this incident, he said, was that about the 23rd May. Last, his Gumashta reported to him that 3 factory carts had gone to complainant's village to bring the factory's half share of Batai Bhusa. Here, at the instigation of Bataidar, his cartmen were assaulted and the Bhusa was thrown from the carts. When the men went to the witness, he admitted he gave them a few cuts on the leg with a light riding cane, but he was very angry at that time. They had assaulted his men badly. It was true that he threatened to fine them, but he had not actually done so. As for their being shut up in witness hen house, it was absolutely false. The men were nowhere near it. Mr. Gandhi asked, "Then half of the riot's story is true?" It is true, he had converted some of the riot's land into Zirat lands. But he had given lands in exchange, and there was no complaints about it. On the exchange lands, the riots had actually sown and reaped their crops. Witness had to convert these lands as it was necessary to have all Zirat lands in one place to ensure effective supervision. It was the practice in all Zamidaris to effect this exchange of lands. This concluded witness evidence, and committee shortly left for Beteha to go to villages in the interior where they intend to have local inspection. Here are some extracts from minutes of Champaran committee meeting. Mr. Gandhi considered that pound should be directly managed by the board and not auctioned. The first topic was cost of cultivation. Mr. Wright said it cost planters Rs 7 to Rs 8 acre for Zirat cultivation. Raja Kirti Anand Sinha confirmed this from his own experience. Mr. Gandhi said that Wright estimated it not below Rs 20 or Rs 25 per acre, but he would examine the question further after seeing the factory books. Mr. Gandhi also urged that volunteer contracts should be limited to 1 year. Sharabeshi. As regards enhancement of rent in lieu of Tankathia recognized at the settlement, Mr. Gandhi thought that it ought to be revised and reduced to ordinary enhancement allowed for the rise in prices. The President and other members were not prepared to agree, and it was pointed out that under the law of enhancement could not be touched in most cases. Tavan. All agreed that Tavan was an unjustifiable practice and should be stopped for the future. The question was then discussed as to what action, if any, should be taken in cases where it had already been taken. Mr. Gandhi thought that where sums had already been paid, no action could be taken, but that the factory should be required to cancel all outstanding debts on this account. He recognized that this could only be applied to the factories which were still the property of the persons who had taken the bonds and not been sold in the meantime. This could be enforced by the Court of Wards refusing to renew the leases of Tikadars who refused to agree to this arrangement. Other members felt that there were difficulties in the proposals which required further consideration. The other discussion was based on existing Tikas. If, in the case of existing Tikas, the estate decided to renew the leases, they should contain following conditions enforcing the recommendation of committee, which included no indigo to be grown except in a voluntary system, no abwabs to be taken, no harja or tavan to be taken. These proposals were accepted. There was another Champaran committee meeting on August 8, 1917, Betea. Mr. Gandhi suggested that the report should specify the more general kinds of abwab so that there could be no doubt as to their condemnation. This was agreed to. Fines. The outstanding point to be settled about the fines was recommendation in respect of cases to which the landlord was a party. The President said that, in his opinion, to adopt Mr. Gandhi's suggestion that in all cases the matter should go to the court would be injurious to the riot and would moreover require legislation. He thought Mr. Gandhi's objection might be met if it were clearly laid down and understood. Number 1, that the payment was entirely voluntary. Number 2, that if the riot thought he was not liable or that the payment was excessive, it was open for him to refuse to pay. Mr. Gandhi said that as the fines were few, so also would be the number of cases in which the landlords would have to report to the court. He thought the power of the landlord over the riots was so great that it would be difficult to ensure that payments were voluntary. After some discussion, it was agreed on the suggestion of Mr. Reid that assessing of the damages should be left to arbitration. Today is August 10, 1970. Another meeting of Champaran Committee. Cost of cultivation. Mr. Gandhi said that he had not yet got the certain figures from Mr. Jameson, but subject to anything new that these might disclose, it was recorded as the conclusion of the committee that the maximum cost was Rs 15 per biga or Rs 10 an acre. Mr. Gandhi said the cost of seed of crops was small, but the President remarked that for rabi crops, it was a considerable item. Khuski indigo. Mr. Gandhi suggested that a minimum rate should be fixed for Khuski indigo. Mr. Ray thought that there might be a danger of this suggestion extending to other crops, for example, sugarcane. After discussion, it was agreed that during the transition stage, in view of the past history of indigo, it was desirable that the association, with the approval of the commissioner, should fix a minimum rate of Khuski indigo. The transition stage being considered to last until government was satisfied that ryots knew that they need not to grow indigo unless they liked. Compensation for abolition of Tinkathia. The next discussion was whether an abolition of the system, compensation, was to be allowed in case where the growing of indigo was recorded as an incident of tenancy. The president, in putting in his view before the committee, said he was anxious to remove anything unjust to the riot. Thought that perhaps Mr. Gandhi, from his experience of a Rayatwari tract, had not fully appreciated the landlord's possession. The proposal he put before the meeting was that a special court should be created to deal with these cases. This court would decide subject to appeal to a special judge. Number 1. If the incident of tenancy existed, and if so, number 2. A fair rate of commutation of the incident. Commutation should be made by an addition to rent and not by a lump sum. In fixing a fair rent as commutation, the court should, number 1. Consider the loss incurred by the riot under Tinkathia. Number 2. The actual enhanced rent paid in similar circumstances for commutation. And number 3. In no circumstances fix a total rent which was not fair and equitable. Enhancement might be made progressive if it exceeded 25%. Mr. Gandhi said he did not wish to enter into legal points, but merely to regard the question from the point of view of equity. The result of the proposal would be that riots in the village under direct management would be placed in a better position than riots in the indigo villages, although the latter had borne this heavy burden in the past which was inequitable. He thought that the evil of the system had not been properly recognized by the committee. Government have never agreed that indigo growing was an obligation, and all the papers showed that the system and its accompaniments formed an intolerable burden on the riots. The proposal did not free the riots. On the other hand, it was a free gift to the planters. It was the planters who wished to give up indigo because whatever might be the case now, indigo was not paying when the conversations were made, and it was not fair to the riots to make them pay for giving up indigo. He had considered the matter from landlord's point of view, as was shown by his agreement in the matter of Tawan. In the present question, he could not separate the riots of Mukrari villages from those of Tika villages. They were in the same position and should be regarded in the same way. He could not therefore agree to anything beyond an enhancement of the rent under the ordinary provision of the law, and proposed any special enhancement in lieu of Tinkathia. He foresaw complications in the action proposed. A settlement by a special court would take some months, which was undesirable in the present state of unrest. An immediate and automatic remedy was required, and this would be the merit of his suggestion of enhancement at the fixed rate on the ground of the rise of prices, that is, of 3 annas in the rupee all round. The president pointed out that in comparing the position of non-indigo riot with the indigo riot, it had to be considered that in villages where abwab were taken, they were higher than Sharabeshi, and that where abwab were not taken, example Madhuban estate, the rent was enhanced to a higher pitch than elsewhere. Admittedly, in Beteha, Kham villages, these considerations did not apply, but it was impossible to secure absolute equality, and in any case the proposal would improve the position of the riot who have been growing indigo. As to the criticism that the proposal was free gift to planters, he said that it was only proposed to allow an enhancement where the legal property of the planter existed, and even then the full value of this property was not being given. He did not think the difficulties of the special court would be great. The settlement records would give a good basis. and the area to be dealt with was not large. Mr. Rainey said the proposal was similar to that adopted in Chota Nagpur, where legislation compelled the computation of predial conditions. He denied that government had never recognized the fact that the obligation might be an incident of tenancy for Section 29 proviso. Mr. Red said the most of the riots took their holdings under an agreement to grow indigo. Mr. Gandhi said the complaint was not against indigo itself, but against the manner and method of growing it. The complaint was not against the system, but against the moral and intellectual damage caused by it to the riots by keeping them backward. The president pointed out that his proposal gave much to the riots with freedom from growing indigo if they did not wish, from having their best land selected for indigo, from supervision by factory servants, from paying compensation for this freedom except in cases where the obligation was the legal property of the landlord, and even then full compensation would not be given. The president said that Mr. Gandhi's position practically amounted to the proposition that the riots should get off paying an equitable rent on the ground of past oppression, which position did not appear to him to be sound. At this stage, the meeting was adjourned. Resuming the discussion of the previous, Mr. Gandhi said that the average amount of sharabeshi taken was about 50% of the rent. The note circulated by Raja Kirtinand Sinha suggested a compromise of enhancement of 4 annas in the rupee to cover sharabeshi and ordinary enhancement on the score of rise in prices. He was anxious to meet the views of his fellow members so far as that was possible. He was prepared to agree to a small enhancement over and above that admissible for a rise in prices, but would not support a penal enhancement. The greatest difficulty would be as regards the sharabeshi already taken. He thought that anything very much larger than the enhancement allowed for the rise in prices would be near the danger point. The president said that he understood the proposal to be that, in cases where the obligation to grow indigo existed as an incident of tenancy or had been commuted by sharabeshi, a slight enhancement, though not a penal one in excess of the enhancement generally admissible for a rise in prices, should be allowed. He pointed out that it was impossible to fix a definite figure for the total enhancement because it was still uncertain what enhancement would eventually be allowed by the courts on account of the rise in prices. The proposal, therefore, could only refer to the amount of enhancement above this figure. He asked Mr. Gandhi to what extra enhancement he was prepared to agree. Mr. Gandhi said he thought not more than 1 anna in the rupee. The president said that the facts were that by a settlement between the planters and the riots, that had been a sharabeshi enhancement of 50%, which Mr. Gandhi thought excessive because of the legal property in exchange for which this enhancement was taken was inequitable, and therefore the enhancement should be reduced. Mr. Gandhi added that there was also the fact that the tenants were not paying rents, and in one case their resistance has been successful. By adopting his suggestion, the committee would put a stop at once to the present trouble, and it was open to the committee to shift the responsibility by suggesting another tribunal. He held the view that 1 anna was not sufficient, and considering the difficulties which had been pointed out by Mr. Rainey, he would be inclined to adopt the suggestion of a general settlement of rents in Mukrari villages by a special tribunal in all the cases where the obligation still existed or where it had been converted. Raja Kirtianand Sinha supported the proposal in his note for an enhancement of 4 annas in the rupee. Mr. Gandhi remarked that if Mr. Adami's proposal was accepted, the committee would have only half done its work. But his main objection to it was that it would add to a ferment which already existed. The committee had the right to confer with the planters, and he thought it would be far better if they could come to some agreement with the planters without the necessity of appointing any tribunal which would delay a final agreement. Mr. Wright pointed out that the 3 concerns mainly affected were Motihari, Pipra and Turcolia, and he was prepared to put the proposal before these concerns. The president remarked that it should be first decided whether the proposal was to be put before the planters as a final one, which they could adopt or not, or merely as a basis for discussion. He inclined to the latter. There was a tremendous advantage in getting the question settled without reference to any court, and as he himself doubted whether 1 anna was adequate, he thought the suggestion should be used as a basis for discussion. Mr. Gandhi said that he would not go so far as to say that he could not agree to anything above 1 anna, but at the time he could not say that he would go beyond this point. Nana was pure concession on his part, because he did not think that the ryots should be called upon to pay any enhancement beyond that allowed by the rise in prices. Reid doubted if the planters would agree to anything under 8 annas enhancement, and pointed out that even in Pipra, which had taken the biggest enhancement, the rents were only rupees 2 an acre. Mr. Reid then suggested that it would be a fairer proposal if the amount of Sharabeshi was reduced by a fixed percentage, say by 25%. Mr. Gandhi said he would be willing to consider that as a basis for a settlement, and would be prepared to go a long way to get goodwill established. It was generally agreed that this was a fairer basis for discussion than the original proposal, and that Messrs. Irwin, Hill and Norman should be asked to come on the following day in order that the proposal might be put to them.